in our communities. Whoa. And that's a good cue for some of the housekeeping items before we jump into all of the good stuff. So, um, obviously, we will be recording so that we can share this forward to our other member clubs. I also wanted to just let you guys know that tonight's webinar is mostly broken into sections based on more specific topics. So we will try to get through as many as possible, but we'll stop for questions sort of after each section. So you can either type your question in the chat box, or you can use the raise hand function. If you do ask your question by coming off of mute, though, we just ask that you introduce yourself so we can kind of get a sense of where you're from. So your name, your role, and the club that you're with. We'll target an hour. I know we didn't specify, but then we'll stay on for a couple extra, maybe 15 minutes to answer any additional questions. And I also want to acknowledge that, of course, we assume there will always be more. It's a huge world of legal implications with a lot of tentacles into our businesses. So we will schedule a follow-up based on today. And if there are any burning items, we will follow up with you guys by emailing any other additional information or any tasks that you guys give us. So also to set the stage, I just wanted to say that this webinar, came directly from your feedback, being the clubs. I think we heard pretty loud and clear that you wanted a better understanding of some of the legal obligations and considerations in operating your clubs. And again, we do understand that, there are sort of relationships between the whole legal world and others, such as the world of insurance and that sort of thing. Some of that Steve will touch on here today, but of course, we will also host these webinars frequently to make sure that we're giving you guys as much education and support as we can. So I think that's all the housekeeping. I will introduce the rock star of the evening. So we're very fortunate that Steve was able to fit us into his schedule. Steve Indig is a lawyer with expertise in sport law. He started his career more than 20 years ago. Wow, Steve.
I know.
We're counting in decades now. He has worked with over 1,000 sport organizations at the provincial, national, and local levels, providing legal and consulting services on a number of items. So that's everything from governance, employment, contracts, disputes, and privacy. I personally have used Stephen and sport law throughout my career, and they have been a fantastic group to work with, all of the people there. But he's not just a lawyer. I think Steve comes with a unique perspective because he is a former athlete at the varsity level. He graduated from Dalhousie University with a degree in rec. He was a swimmer and competed all the way up as a qualifier for the 2000 Olympic trials. And he's even a Hall of Famer. So he was inducted into the Nova Scotia Sports Hall of Fame back in 2007. It goes on, you guys. He remains actively involved in sports as an athlete and coach, and coaching his kids too. So he has tons of experience also speaking. Again, I've done tons of work with him. And if he ever doesn't know an answer, which is not frequent, he finds us one. And he also is, my personal opinion, a great storyteller. So these sessions are also pretty entertaining. So thank you for being with us, Steve. And the floor is yours.
Okay, thanks, Jill. That was a wonderful introduction. I really appreciate that. And always when I hear that, it's nice to look back and go, really, I did all that? That's kind of cool. So always nice to hear. I appreciate everybody's time tonight. What I want to do is tell you quickly about sport law, and then we'll get into the meat and potatoes of tonight. I would ask preliminarily, if those of you who are comfortable turning on your cameras, that's helpful for me as a presenter to talk to you rather than talking to myself or my colleague here, Mike, will leave his camera on, but I see his face all the time. So those of you who are comfortable, please do turn on your cameras. As Jill said, I have a very open presentation style. So those of you who want to type in a question, we'll find a way to answer that. if you're not comfortable asking your question in a public setting like this, I'll put up my email address at the end of the presentation. You can absolutely have tonight's slides, so please don't feel you have to write down everything. I'll make sure Jill gets a copy and it gets sent out after tonight's session. We may not get to everything. Jill and I put together a pretty extensive list, and of course, trying to limit a lawyer to do a presentation in 60 minutes is always a bit of a challenge, but I am going to try. For those of you who don't know about sport law, we've been around 32 years. I've been here 23 of them, going on 24. We are a group of 20 consultants whose design of the company was to provide a one-stop shop for amateur sport across the country, be it legal, leadership, coaching, risk management, financial oversight. We tried to hire somebody with the experience in those particular areas to be able to answer your needs. There's a copy of all our team, and you can learn more about everybody on the website about what everybody specializes in. The website is sportlaw.ca. There are over 600 articles on the site about pretty much everything and anything in sport, from transgender inclusion to concussion management to complaint management to employment issues to risk management. It's all searchable. So in the top of the website, if you have a query or an interest in a particular topic, just type in that word and it will pop up. What I want to do tonight, and you can see the list is a little long and we may not get to all of it, and that's totally okay, is really start from the top. And what I love about pickleball, my sister-in-law, about over a decade ago, and this was kind of pre-pickleball boom, built a cottage about an hour outside of Toronto, and rather than building a tennis court, built a pickleball court. So her family and our family have been playing the sport for, I'm going to say, 10 to 12 years, really before the explosion of the sport. So I'm familiar with the kitchen and the way that we score keep and all of those different things. It's a great sport. My wife runs a summer camp. We built 4 pickleball courts last summer that are absolutely packed with kids enjoying the sport, and of course more so than tennis. Don't tell the tennis people, but it's very popular place. So I am familiar with your sport, and what I like about it is, even though you're new, that also gives you a carte blanche to kind of start and do things the right way. So I actually had a call at 8 o'clock tonight in Toronto about incorporation, and the organization I was talking to was actually opposed to incorporating. And I'm a big advocate to say that that's a terrible, terrible idea. The first thing about incorporation, one of the advantages is the liability. The law recognizes 2 things: corporations and people. And in Alberta, of course, the society would be deemed to be a corporate entity. And when we create that corporate entity or that society, we get what we call the corporate shield. So any activity that occurs within that circle protects you as a person from liability. And I always argue with people to say, like, the cost of incorporation or the registration of a society is usually under $200. You're going to pay $200 just to walk into the lobby of a lawyer's office just because you have a question. So to create that additional level of protection, for me, is fundamental. Those of you who are involved in the operations of a club or the provincial body or maybe Pickleball Canada, you don't want to be exposed to your personal assets because you failed to fall within that corporate shield, within that circle. And again, the simplicity of it is to simply register. And when you register, some other benefits come with that. You have greater access to funds. Most grants or other types of loans require some sort of corporate status. We have a legal principle behind us for the formalization of rules. Fundamentally, there's the Societies Act, and then there'd be other pieces of legislation that you would be subject to, and that helps provide you guidance and direction and decision making. I'm going to say this later in the presentation, but policies are your best friends. They help you create a roadmap on decision making. Incorporation provides you name protection, and it also allows you the ability to carry on an entity after the retirement or the removal or simply a person leaving an organization, it in perpetuity, we just reelect new board members. We don't have to sell shares. We don't have to sell assets. You just reelect a new board, reestablish your membership base, and that organization continues in perpetuity. So there really are a lot of advantages in incorporation. Fundamentally, for me, is the liability. I would hate for anybody to be exposed to personal liability because they volunteered their time for an organization that they love. And sometimes people sue not because of anger, but because of necessity. Maybe they can't work and they need income to pay their mortgage or their payments or their kids. It becomes a necessity and not necessarily an anger issue. So it happens, and this protects you from that. There are some disadvantages. Yes, you do have to register and you might need to retain legal counsel to help you incorporate and do the name search. You're also required to file a tax return. Most not-for-profits do not, but there is a legal obligation to do so. And there is increased paperwork as you're required to have articles and a minute book and resolutions and file annual notices with the society, register of societies as to your board composition or your registered office. If you really start doing it and getting into that groove, it does become a bit of a common practice and a significant small workload for the advantages of the corporate shield, in my opinion. The corporate records that you're mandated to maintain are your articles of incorporation or your registration of society, your bylaws, your minutes of meetings and committees, resolutions of the directors, and a list. You should know if I were to ask Jill rhetorically, who are the members of Pickleball Alberta, she should be able to tell me that pretty instantaneously. If we don't know who our members are, then we should be able to we want to be able to figure that out. And of course, we need adequate accounting records to be able to report appropriately to our members and if we are required to file a tax return. So yes, there's a little bit of work that comes with incorporation, but again, for volunteer, and you just never know. I recognize that I work in the world of 1%, that it's very unlikely you will get sued, but if you do, it could be catastrophic. And that's, of course, what we're trying to protect from. So that's a good segue into litigation and understanding negligence, which is the majority of the reasons why we want to be incorporated, why we want to have risk management techniques in place. Is one is we don't want people to get hurt. But two, unfortunately, sometimes it's an associated risk in sport. We want to make sure that we understand our legal obligations to create a safe environment. There are actually legal cases where people have been paralyzed, particularly in the sport of rugby, where the individual was deemed to have accepted the risk of rugby and there was no legal liability after he was injured because it was a common risk associated with the sport. And that's why we need to understand, how does negligence apply from a legal perspective. So there's a four-part test that exists in law. And in order to be negligent, we have to say yes to each one of these bullet points. So I'm going to go through duty of care and standard of care, but there actually has to be harm. So if Mike here trips and falls at one of your events, gets back up, and is not injured, he can't sue for negligence. But if he breaks his ankle and he can't work for 3 weeks, and there's damages which can be compensated by money, now I've got a harm or a loss. And of course, the breach of my standard of care has to be all correlated to make sure there's that negligence. So when we talk about negligence in a sporting context, the first part is usually pretty black and white. Do I owe a duty of care to that person? And the short test is, to anyone who ought to know could be affected by my actions. So in sport, coaches are responsible for their athletes. Clubs are responsible for their participants. Host organizations are responsible for creating that safe, welcoming, abuse-free environment. So usually in sport, the duty of care is fairly well established. You all are familiar likely with the structure in sport being club, provincial sport body, national sport body. a lot of times we'll see litigation that occurs at the club level, and they'll sue the provincial body and the national body. Most of the time in those scenarios, the upper level bodies are able to say, I don't have a duty of care to make sure what happens at that club level. That's something that stays within their circle, but it is possible that it creeps up, particularly when we talk about abuse in sport. Was the screening of the coach the responsibility of the club? Was it the responsibility of the province? Was it the responsibility of the national organization? And unfortunately, I know we're recording this, but I think it's okay to swear. I always say in sport, the shit runs uphill. So if a club has an issue, it's likely going to end up at the provincial or territorial level and potentially at the national level. And that's why it's really important in sport to create what I like to say consistency. Having 17 codes of conducts within Pickleball Alberta or even Pickleball Canada is ridiculous. We should be all working from the same songbook. Discipline process could be the same, policies could be the same. I know I'm going down a bunny hole here, but about 7 or 8 years ago, a national sport organization asked me to do a policy inventory across the country. And we went to every provincial and territorial body and the national body and said, send us your policy suite. There was 638 policies across that sport. And that was crazy. And what we did was we broke it down into pillars: administrative policies, operational policies, and governance policies, and started picking away to create consistency across that sports sector. So I'm a big advocate for consistency. And when I talk about standard of care in sport, and I'll get to it on the next slide, but we talk about trends in the industry. Why is this okay in Calgary but not okay in Edmonton? We want to be consistent in our sport. And you'll also see there's some suggestions when I get into the insurance topic from Pickleball Canada about the use of waivers and the consistency of the abuse coverage, or there are abuse policies that must be adopted to get abuse coverage. So I know I'm getting a little ahead of myself, but I wanted to talk about, all right, do I owe a duty of care to that participant? Now, even though an injury may have occurred, if we can prove that the way we've acted is reasonable, like that rugby case I spoke about before, even though there's injury and we have not breached our standard of care, we won't be liable. So I want you to think of standard of care like a line. Is that line way up here? Is that line way down here? How do we figure that out? And it's looking at these 4 standards. So written rules. What do your organizational policies say? And sometimes in different sports, we have, I'll give you an example. Years ago, we did a risk assessment for speed skating. They wanted to know what the appropriate size of the mat should be around the rink when people crash and fall into it. And based on doing research, I'm making this up because I don't remember, but we said it had to be 3 feet thick. So we went out to all the clubs in the provinces and said the standard of care for mat size is 3 feet. And we got massive feedback because new mats for certain organizations would have been tens of thousands of dollars. So rather than making it absolute, it became a recommendation. So language is important when we look at policies. You will is absolute. You may is discretionary. But when we see your rules or your regulations particularly say will, you have to follow them. And I will repeat this multiple times in tonight's session. Policies are your best friend. But if you don't like them, change them. Things evolve. 20 years ago when I started and Jill would call me and say, hey, Steve, we need new policies. How many do we need? I probably would have said 5, 6. Today it's about 30. And the world has changed. Inclusion, accommodation, legalization of marijuana, trans inclusion, privacy legislation, anti-spam legislation, workplace harassment, abuse in sport, code of conduct, screening, just to name a few, that says sport is becoming more onerous as we continue to evolve. So those written rules, please read them. If they're not applicable to you or you feel that you can't comply with them, call the board, call somebody to have a conversation to make sure that you are consistent in the trends in the industry, but also that you have the ability to implement what that policy says. The second way in which we determine that line is the unwritten rule. What is the trend in the industry? So I'm making stuff up here. Are eye guards mandatory for pickleball? Is there other protective gear that's starting to become a trend in the industry? When we talk about weather conditions, what's the trend in the industry? And if everybody, I always like to use this example. When I was doing some work for Parks and Rec Ontario, they wanted to know the ratio for lifeguards for number of swimmers in the pool. And we went out and asked a million different people what the ratio was. And of course, a lot of it had to do with pool size and resources. Could they afford the number of lifeguards required? And we ended up basically at this number of 1 to 12. That would be the trend. So if you're not offering lifeguard services at 1 to 12, why not? And you better have a good reason as to the why not, because that's the trend in the industry. Of course, there's case law. The courts have looked at injury within sport. And because of time tonight, I didn't want to get too much into the case law, but basically the standard established by courts is what would a reasonable person do in a similar circumstance? So if Jill's a coach and Mike's a coach, were they acting similar to each other? And if not, why? And it's based on a reasonable standard. And it would be compared to a person in a similar circumstance. Your board, your athletes, your coaches, what would they do? And the last thing, of course, is following common sense. So Jill mentioned storytelling. I have a lot of them. I got a call a couple years ago from a client saying, "Hey, we're sending a bunch of U12 athletes to California for a competition. Do we need a chaperone?" And my response to them was, "Do you have a child?" And she said, "Yes." And I said, "How old?" And she said, 13. And I said, "Would you send her to California without a chaperone?" And of course, the answer was absolutely not. So you follow your common sense, your gut, your intuition. That's also going to give you the answer on what we should be doing in certain situations. So as I mentioned, that's the line. So if I can prove my conduct is in that white box, even though I might have an injured person, we might not be liable to that person because we acted within our standard of care. If we're in that red box, that's when we call our insurance company and they may have to cut us a check. So we have the ability to control that standard of care. And I'm going to give you a couple techniques that you can use to try and figure out what that is. And it's really risk management. And risk management is really three questions. And I endeavor to write this down on your board agenda. For every decision the board makes, ask these three questions. Okay, if we host a tournament next weekend at such and such facility, what can go wrong? Well, if it's outdoors, there's weather conditions, there's wind, there's maybe anaphylaxis, bee allergies. What's the likelihood that that's going to happen? Can I control it? And how do I do that? And I think if you ask those questions on every decision, it's going to make you think a little bit broader than particularly just, making that quick decision. What's the likelihood that something can go wrong, and then what's the ability to control it? So when we talk about risk, and all the pictures in here are my children. They're much older now, but this is the way we managed risk management in our home. Was lots of equipment to make sure they were protected playing baseball. When we talk about risk, compliance risks. Did you file your paperwork? Did you file your tax return? Did you file your annual return? Did you provide notice to the ministry? Financial risks. We have a client right now who just hired a forensic auditor to review the conduct of the CEO. And that's something that's occurred over the last 3 years. Do we have practices in place to ensure that there's dual signatures, that it's money spent within the budget? Do we have governance risks? Our board's too big. We don't have the right people involved. I had a conversation this morning with a CEO of an organization that was spending more time answering questions of the board than actually trying to do her job of running her facility. And that sometimes is a governance issue or a people problem. We have communication risks. People are talking poorly about us. Sometimes our programs may not operate. And again, that reputation is sometimes in our world, if no one's talking about you, that's a really good thing. There's complaints to consider, inclusion, the use of social media, abuse reporting, the rule of two, which is we always want to have two hopefully certified coaches in presence, if not at least an adult and another certified coach around children, human rights issues, concussion awareness, employment risks. The list goes on and on. But we want to evaluate the risk. Okay, it's low of this happening. What's the likelihood if someone's going to get a bee sting at an outdoor activity? Well, it's probably pretty low considering there's no garbage around, it's fall, and it's very unlikely to happen. Or it could be catastrophic. Are we prepared to deal with this issue? So applying your evaluation of risk is going to help you decide on what to do with that risk. You could retain it. We're going to just do nothing. The likelihood of this happening is low and it becomes inherent in our sport, and we're not going to do it. Or we're going to just leave it as is. The other thing we can do is reduce the risk, and we do that by changing human behavior. Hey, Jill, don't go to this side of the court. There's a big pothole, and we've wired it off with yellow tape and a pylon. Don't go over there. Educating people on the risk is important and telling them what's going on. We can transfer the risk, and we do that through contract, through insurance, through waivers, through subrogation, through creating other corporate entities. When the Vancouver Olympics happened in 2010, 2012, I can't remember, the Canadian Olympic Committee and the IOC created VANOC, the Vancouver Olympic Committee. It was a separate corporate entity to take on the liability and responsibility of running that event. And that would create a that circle around VANOC, but preclude the liability from reaching up to the Canadian Olympic Committee or to the IOC. So there are different technology, different techniques. And the last one, of course, is wow, the risk is just too high. We should not be doing that. So ask yourself, what can go wrong? What's the likelihood of it going wrong? And can we control it? And, again, I'm going to talk about waivers. Insurance, we're going to talk about insurance. We're not going to really talk about contracts, but look in your contracts. Do you include an indemnification? Indemnification means to put somebody back into the same financial position they were in today than after litigation. Who's responsible to pay those fees? Is it the organization? Is it the individual? We could always look at subcontracting, again, passing off the liability or creating a joint venture on that. I want to move particularly into that waiver and insurance component because I think it's really an important topic. So a waiver is a contract where a participant agrees not to hold a particular group or entity responsible for the legal risk of negligence. And again, it's interesting on sometimes on the misconceptions. On my 8 o'clock call tonight, somebody actually said to me, well, you can never waive negligence. You can't stop somebody for suing for negligence. And that's not true in the common law in Canada. That Mike's smiling. I can see him thinking because it's not true in Quebec. Quebec, it is very difficult to prevent somebody for suing from negligence. But outside, and particularly in Alberta, we can prevent that. And that is the whole and purpose of a waiver, is to say, hey, Jill, come play pickleball. You might get hurt. It might be our fault, but you can't sue. So from a legal perspective, it's a very awesome risk management technique. But from an ethical perspective, it can be very complicated. And in preparation for tonight's webinar, I was reviewing Pickleball Canada's insurance page, and they've actually got a couple really good bullet points to talk about the relevance and the importance of waivers as a risk management tool for an organization. So I really like the reasons they had provided. If you Google Pickleball Canada insurance, you will find that link to that information. There are two types of risk in sport. There's the physical risk and there's the legal risk. The physical risk in sport is common sense. So if I play pickleball, it's going to be slip and fall, run into my partner, get hit with the ball, get hit with a paddle. Those are all common risks. Or if we play hockey, it's to get hit by a puck, excuse me, to get checked. Those are all different components that we don't need a document or a contract to assume that risk. We assume it by virtue of playing the sport. Now, what I like about a waiver and when we write them is we are very specific in the document to describe those risks. So Jill can't say afterwards, I didn't know that I could get hit by the paddle playing doubles pickleball, or I didn't know that I could get a ball in the face or in the eye. I want to be as descriptive as I can in the waiver to describe those physical risks associated with your sport. The second risk is that of negligence that we just walked through. In order to waive negligence, there has to be a written contract to do so. So it's risk that's not inherent in the sport, that's not desirable, reasonable, or acceptable. So for argument's sake, again, silly examples, if there's a big pothole on the court and we told, the four of us on screen, you have to go play at that court, even though there's a pothole, that would be negligence. And again, the only way to waive negligence is through the use of a waiver. For those of you who are using waivers, please listen to what I'm going to say, because the enforceability of a waiver, of course, is challengeable, but we want to create steps in place to make sure that that doesn't happen, or that if it is challenged, that we have the best defense possible. So one is the waiver being used in appropriate setting. And for pickleball, I would say absolutely. Is the waiver easy to read? Please have it as a standalone document, not embedded with your registration form and your name and your address and your phone number and what program you want to participate in and whether or not I get to take your picture or send you spam. I want it to be a standalone document and not 6 font. I want people to be able to read it. I want to make sure the content is clear. I want to include all the activities that I'm looking to be indemnified for: practice, training, parties, transfer to and from the event, playing the game. You can get the idea. I also want to include all the parties who I'm indemnifying. You can't rely on a waiver unless you're an included party. So if it says, I agree to indemnify Steve Indig, Mike can't rely on that and say, hey, Jill signed a waiver and rely on it. Mike would have to be specifically named. So make sure, particularly in sport, we try to include everybody: the national body, the provincial body, the club, and probably the facility that you're in. And that would also include your directors, your committee members, your volunteers, your officials. We want to be as specific as possible to include everybody. The last part I want to speak about is execution. Please have people, give them ample opportunity to review the document in advance, to have them show up the day. If me and Mike are playing doubles at 10 o'clock and you come up to me at 9:55 and say you have to sign this before you play, it's likely not to be enforced because you haven't given me the opportunity to weigh the consequences of signing or not signing. So send it out in advance with your registration package as a standalone document. Give them time to seek legal counsel. Give them time to review it. We want them to execute it voluntarily. Yes, you will potentially have people come back and ask you questions or questions the ethics behind a waiver, and you just need to be ready with those answers. And again, referring to Pickleball Canada's waiver and insurance section, I do think there was a lot of good language in there to support the use of a waiver. So I want to be consistent, ask them to sign in advance, allow them ample opportunity to review, try and use a witness, make sure there's no alcohol around when you're asking people to sign, check for proof of age if you're unsure if somebody's a parent or guardian or under the age of majority. And the question that comes up all the time is, how long do we keep them? And the legal answer is forever. And in today's electronic environment, scan them, save them as 2024 waivers, keep them in a file, back it up, and don't lose them. The statute of limitations on litigation is 2 years, but it's not 2 years from the date of the injury. It's 2 years from the date of discovery of the injury. So if Jill gets hit in the eye with a pickleball today, and 9 months, 10 months, 2 years from now discovers there's an injury, that starts the timeline as the discovery of the injury, not the day she got hit. So that's why we always recommend you keep them as long as possible, just in case of those claims. The other thing, just because I'm thinking about it, is keep a copy of your insurance policy. And I like to say this sometimes, you can't make this up. So we had a client reach out to us. They were sued from an incident that occurred in 1986. So their current insurer says, we only take coverage, we only apply coverage from the date you bought the coverage until the date it expires, which would be 23-24. You need to go find out who the insurer was from 1986. So we got a call to help facilitate that. And we were able to track the insurance down to 1987. We were not able to pull it back to 1986 because, funny enough, the 1986 coverage was the same company that we started with in 2024. So it was a little bit of a circular exercise, but the current insurer had no record of the 1987 policy. So keep your insurance policy handy again in today's technology. Now, one thing again that I was able to copy out of Pickleball Canada's website, Pickleball Canada requires all participating in a Pickleball Canada event to sign a liability waiver. That liability waiver releases Pickleball Canada, the PTSO, its club, and its members from any and all claims. So I really think this is something that your insurance policy and your insurance provider is likely mandating as a requirement for insurance coverage. So if you are not getting waivers signed, I would definitely look into having that done, or at least having a conversation with Pickleball Alberta or Pickleball Canada on the obligation to do so. But my reading of what was posted, it seemed to be a mandatory requirement for insurance coverage. And we are seeing that more and more and more, as the insurance companies, of course, don't like to pay out. And a waiver is a great risk management technique to prevent that from happening. So do waivers work? Absolutely, if they are done properly. I guess any questions? I don't see anything in the chat, Jill, so maybe I'll keep going. If people want to unmute themselves or raise your hand, please feel free to do so. So let's move into insurance. I have a love-hate
Hello?
relationship. Hi, go ahead.
Oh, I just got a thing. So, Jill, you might know the answer to this question. What, I can't think from the previous year or so, with regard to a waiver and the insurance part, because if I'm correct, our insurance, when we become a member of through Pickleball Alberta, Pickleball Canada, we get insurance through them, right?
Yes, it's included with your membership.
Yeah.
However, so I was actually texting in real time as Steve was storytelling. I didn't actually realize that I don't believe Pickleball Alberta provides a sample waiver to our clubs though.
Okay.
So we will fill that gap as soon
Okay.
as possible. So you still
Okay.
have that waiver in place. Absolutely. And, this is one of the stories I've heard Steve give this presentation before, and I just want to cover it. When you get that sample waiver from us, it will have like insert club in the blanks. What we need you to do is actually insert the appropriate name of the clubs, and rather than just adopting the policy without tailoring it to your club's specific needs. Otherwise, as a legal document, it won't hold up.
Yeah.
Thanks
Yeah,
for
because
the story before, Steve.
That's a
yeah,
good
just
story.
because my and maybe this can be discussed later, I don't know, but I guess when we had that waiver, trying to figure out the best way to like people sign up to become a member of our club. How do we get that waiver signed? I guess, you know.
Yeah, I think there's two ways, Grant, of doing it. Of course, a lot of organizations are moving now to online registration. So,
Yes.
here's a link, click the link, name, address, phone number, program I want to participate in. And then there are ways of having, you can definitely execute a waiver online as well. There's ample
Okay.
case law to say that the electronic execution of a waiver is enforceable. So you can definitely look at it that way. I would recommend it, of course, from a
Yeah.
storage perspective and an administrative perspective. That's very helpful. There are systems like smartwaivers.com is a good one. I'm trying to think of the other ones, but there's a few of them that of course, you pay a fee. I don't think it's a crazy amount of fee to do it, but there are options out there, or you have it embedded in your registration system. You know, Jill, I'm glad Jill listens to my story, so that's really nice to hear. But Jill brings up a good point when we talk about policy and waivers and contracts. Yes, Google's a great tool, and borrowing documents from your PSO or your NSO is awesome. I totally support it, but read it. And if it says Pickleball Canada will, I'm not sure they will in a club setting. So maybe you have to substitute the word Pickleball Canada for the club. And the story Jill was sharing was actually a client had asked for a template waiver, and we had wrote at the top, insert name of club. And that organization went and got 400 people to sign a waiver that said, I agree to indemnify, insert name of club. So
Mhm.
that document, of course, was garbage because the indemnification was applied to nobody. So big advocate of not recreating the wheel, but ensuring it works for your organization.
Yeah, because I'm thinking same thing with things like code of conduct and those things, because you want members to be basically aware of that, you know, while signing up, and then you're covered on the front if, you know.
Oh, the I love, like, at point of registration is the best time, of course, to get
Yeah,
all this stuff signed. And some of the routine
yeah,
things that we would see would be, of course, as I said before, name, address, phone number, email, image consent, privacy consent, rules and regulations consent, and then the waiver would be standard terms we'd see in the registration
okay.
documents. And fill them all out before you come play, and now you're good to go. There's a comment in the chat box about registration with Pickleball Canada meant individual clubs didn't need waivers, and again, I would say that depends. As we spoke about a waiver, the waiver is applicable to the parties listed to be indemnified. So a club cannot rely on a waiver that says, I agree to indemnify Pickleball Canada. It needs to have at least a reference to the clubs. If it had your name in it, even better. But I don't think simply registering with Pickleball Canada provides you an indemnification. It does provide you insurance. As Jill and I spoke this afternoon, Pickleball Canada provides a national insurance policy coverage. And when an individual registers, they do get certain protections under that insurance plan. And maybe that's a good segue to talk about insurance. So, as I started, I have a love-hate relationship with insurers and brokers, because what happens is a lot of times people will always ask, what's covered? Are we covered? Are we covered? Are we covered? And a lot of times people will say yes, yes, yes. But the real answer is maybe. And the real answer is maybe because insurance policies apply in certain situations, have listed detailed exclusions that we need to be aware of. I actually had a client say, hey, Steve, can you read our insurance policy? Let me know if you see any gaps. So I went through the 69 pages, and of course, it's not the most exciting read that any of us have ever had. And on page 69, it said, this policy is excluded from sporting activity. So I called the client and I said, don't read the first 68 pages, turn to page 69. And she turned to page 69 and laughed and said, I'll call you back, because obviously there was a miscommunication between the coverage provided. So you need to ask the questions. And again, Pickleball Canada has done quite a nice job in trying to share this information with you on its website. So that's the source of my information here. First question is, who's covered? Pickleball Canada, its members, its provincial bodies, and its affiliated clubs. Okay, that's great. What is covered? So it's sanctioned, authorized activities. So I sometimes divert back to all of you, and I'll pick on you, Grant, just because I can see you, is like, if you're a club organizer, what part of your activities are sanctioned and what are not? So we like to create sanctioning policies and say, okay, practice is sanctioned, competition sanctioned, travel to and from is sanctioned, but going to the US is not, or having a bottle drive or a car wash is not, or a fundraiser. So you can see what Pickleball Canada has shared with you and said, okay, sanctioned authorized activities are covered, and they include pickleball played by a member. So what happens if a member is playing a non-member? It's probably not sanctioned. Tournament play in Canada is covered. Coaching, teaching, rating, refereeing is all covered. Demonstration, board meetings, social activities that do not include alcohol. So if alcohol is being served at a social club event, there is no insurance coverage related to the use of alcohol or the potential injury related to alcohol. Why is that? Oh, sorry, wait, did I skip? What's excluded from coverage? Private clubs. So if you are a for-profit business, you do not fall under the Pickleball Canada coverage. If it's a social activity not held in conjunction with an authorized activity, so is it a post-tournament banquet? What is it? If you have alcohol, if you have a virus outbreak or disease, and all activities other than playing or practicing pickleball. So if you decide as a group you want to go play cricket or a basketball game because it would be fun, that's not included in your coverage. Do you have enough coverage? So your general liability for damages for bodily injury or property damage is $5 million. I would say that's right now a reasonable amount. You are seeing organizations buy $7 or $10 million, but I do think $5 million is probably appropriate in today's environment. You have $2 million in negligent error, misstatement, or misleading statement. Usually errors and omissions is decisions made by the board or decisions made by staff. You'll see again exclusions on the errors and omissions coverage from wrongful dismissal claims. So those of you who have employees won't be covered on a wrongful dismissal claim, board members suing other board members, or professionals relating to their own practice. So if you have a lawyer on your board, or an accountant or another professional, their own insurance would kick in first. There's no liability for liquor. You would need to buy that as an add-on. So if you are serving alcohol at your banquet, this is something you should look at. It's not provided. Abuse, hot topic in sport today. And we are starting to see abuse exclusions from policies, or they're being bought in addition to. You have $500,000 in abuse coverage. That's only if you have adopted and implemented Pickleball Canada's abuse policies. And again, if you go to the insurance page, you'll see the link to their policies for that particular for that particular policy. Abuse coverage is expensive. $500,000 is probably not enough, in my opinion. I have seen claims over my tenure of larger payouts than $500,000, but I do recognize that it's ridiculously expensive to buy. And some organization have decided that they will take on the liability without insurance because the premiums are too expensive. That's an informed decision that you as a board have to decide whether you want to buy additional policy, additional coverage. There is also no cyber or data breach insurance. So if you're hacked and your information ends up, my information or your member's information ends up in the public domain and somebody sues you because of that, you again would be on your own with respect to that. So that there's a really good, as I said, explanation on the Pickleball Canada site relating to insurance about what you have and what you don't have. And you may want to speak to a broker to find out if there's additional coverages that you may be interested, or you're okay with assuming the risk. Remember our risk management techniques to retain the risk and do nothing. But please make an informed decision. I think we'll do this, Jill, and then we'll open it up for dialogue. So I've mentioned a few times that abuse in safe sport is a very hot topic these days across the country. I'm sure a lot of you have read the articles in the newspaper on CBC and TSN with the allegations of maltreatment in sport. And there's been a significant movement, particularly at the national level and within the province of Alberta, on the establishment of more robust safe sport policies. So complaint management is becoming a key responsibility of clubs, provincial bodies, and national bodies. I've said this a few times, policies are your best friends. You run into problems when you don't have a policy. When safe sport became a very hot topic about 2018, I believe, is when it really started getting steam. I got a call from a client saying, "Hey, Steve, we opened up a safe sport hotline." I was like, "That's fabulous. That's awesome. Good for you. Way to be proactive." And then 2 weeks later, I got a phone call saying, "Hey, Steve, someone called it. We don't know what to do." And I really had to shake my head and say, how can you open up a hotline and not knowing what to do when the phone rang? And that's why they didn't have policies or procedures or education in place to deal with a complaint. So I want policies to lead my actions. If they're incomplete, vague, or contradictory, try and streamline them. Those of you who have a code of conduct, a harassment policy, an abuse policy, a discipline policy, an appeal policy, you probably only need one. You don't need five, you need one. So we want to make sure there's consistency. If your policies do not work for you, change them. But you can't choose to not follow them. Make sure they fit within your culture and your resources. And people ask me all the time, how often should we review policy? And I mentioned before that we always recommend somewhere between 20 and 30 policies as a sport organization. If you do 3 every year, it takes you 10 years to get around to a review on the first ones. So, and in today's environment, and Jill would know this from her role, particularly with Curl Alberta, like safe sport policy suites that we wrote 2 years ago are being changed already. And they were changed 2 years before that. And the Universal Code of Conduct, those of you who are unfamiliar with it, was a document put out by Sport Canada to recommend, appropriate conduct in sport. They've already changed it twice, and likely it's going to change again in April. So it's a very quickly changing pace, quick changing area. Policies are your best friend. Hi, Steve, I got a complaint. What do I do? Jill, what do I say?
What does your policy say?
Yes, awesome. Exactly. What does your policy say? Because we talked again at the beginning of the session that when we incorporate or when we establish an association, we create governing documents. That's a contract. That's a contract between us as an organization and you as members and you as participants. And there's case law to say when I pay my $3 to be a member, I am now subject to those guidelines. So there's that contract. They'll help you avoid a problem. They will help you manage they will also help you manage your problem. So really adopt policies. I'm a big advocate for consistency. So if there is the ability for Pickleball Canada or Pickleball Alberta to create a suite for all its clubs, I love when you all sing from the same songbook. That way, Edmonton can call Calgary and say, "Hey, how did you deal with this? Do you have people that we could use, or vice versa?" When you get a complaint, who gets it? Do you know who gets it? And again, you want to be proactive, because what happens in complaint management is, first I'm mad because I've got a complaint. And then that grows because I've submitted that complaint and the organization is not prepared to deal with it. So now I'm mad at the complaint. Then I'm mad at the organization for not having the resources or your ability to manage it in a timely basis. So I want to know in advance who is going to receive complaints. Complaints must be in writing. We also don't recommend time restrictions. A lot of people who are subject to severe abuse in sport or maltreatment, it takes months, if not years, for them to come forward. Don't say it has to be filed within 14 days or we won't hear it. Or if you do say it has to be filed within 14 days, give yourself an exception to extend that timeline, because we don't want to allow an abusive person to stay in sport because of a 14-day time limit. Sometimes it will be in your best interest to, as the organization, act as a complainant. That's okay. And again, you might want to have 2 or 3 people deep of responsible people, because they might be away, they might be in conflict, they might have already dealt with that person on a previous complaint. So try and have maybe 2 or 3 people available. And again, I love sharing resources. So again, maybe we can have a couple people who can deal with this stuff provincially and not have to worry about it. When we talk about the complaint, make sure it's in writing. We want everything at the beginning of the complaint. I don't want email after email after email. Grant, you have a complaint? Yeah, okay. Well, take as much time as you need to put your complaint together and get your witness statements, or if there's a video, download the video and submit it to me when you're all ready to do so. Because once you've done that, you will not have another opportunity to submit evidence. Because I'm going to talk about this on the next slide. Complaint management requires procedural fairness. If I have a complaint against Mike, Mike needs to know what that complaint is, and Mike needs a fair opportunity to respond to it. And every time new evidence comes in, I got to give Mike a chance to respond to it. I could go on forever. So, Grant, take your time, collect your evidence, submit it all at once. Let me know what parts of the code of conduct you think have been violated and why, and what is the remedy you're looking for. And a lot of times we ask that question because it's about managing expectations. Grant, I've been doing this for 23 years. Mike is not going to be expelled from the sport because he spilled coffee on your shirt during a timeout. That's just not going to happen. You are likely going to get an apology and maybe a letter of reprimand, but that's about it. So it's really about managing expectations. If the complaint is unclear, ask them to rewrite it, right? It's not necessarily our job to go through 33 pages. And funny, I say that because I got an email today from a client. Hi, Steve, we just received a 33-page complaint and it's all over the place. Do you have a complaint form that we can use to help streamline people's complaint? So don't be afraid to do that. Procedural fairness is a legal principle that we have to adhere to if we want to take away a benefit provided to an individual. So one, do I have the authority to do that? And that would be dictated in bylaw or policy. A right to a hearing is not a court-like setting where Mike's on the right side of the room and I'm on the middle and Jill's the judge at the top of the stage there. That's not what right to a hearing means. It means the right to know the case against you and the right to defend yourself. Fundamentally, I always say complaint management is relatively easy, and I say that with an asterisk, of course. Grant, write your complaint about Mike. By the way, Grant, that complaint is going to be disclosed to Mike. He's going to see it, and he's going to be provided an opportunity to respond. Well, I don't want Mike to see it. I'm sorry, Grant. in order to be legally fair in this process, he has to see that. We need to have his side. Do you want to rewrite your complaint knowing that he's going to see it? And you say yes or no, and then we send that documentation to Mike, and we say, Mike, a complaint's been filed against you. Here's all the evidence. You have 10 days to file a response, and we're going to make a decision based on the complaint, the response, and there might be a rebuttal document in there somewhere with a fair decision maker. Now, again, the content of fairness is not the same. When we talk high level extreme, that's that court-like setting. Okay, Grant, go ahead, address the panel, tell them why you have a concern. Thank you. Mike, let's hear your side. Majority of cases can be decided by document review. Most people in an oral hearing read their documents. The reason why we would do an oral hearing is to determine the credibility of a participant. It's very easy to lie in writing. It's a little less easy to lie on Zoom. And of course, it's most difficult in person where we can see people's body reactions and things like that to determine credibility. So don't think that every time you have a complaint, it has to be a formal like hearing, in a court-like setting. It absolutely does not. It could be as simple as an oral interview, document review, or a combination of all of those things. The way we decide based on the hierarchy is what's the outcome. So if Grant, if you're looking to have Mike expelled, I'm going to maybe have an oral hearing. The Sport Dispute Resolution Center of Canada, they oversee all decisions at the national level. Their default model of a hearing is virtual. And I can tell you in 23 years, I've done 2 in-person hearings. I've done 200 on Zoom or whatever the number is. So at minimum, I like doing the written document exchange. And then if it gets a more serious complaint, we would offer that oral hearing. But it does not have to be the same in every situation. Know who's going to get the complaint. If it's not filed within the correct jurisdiction or it's better managed at Pickleball Alberta or Pickleball Canada, send it up. Inform them. Let them know this is happening. Inform the parties. Let them know that you've been appointed case manager and you'll be facilitating a process. If the complaint is frivolous or outside the scope of the code of conduct, you can dismiss it. There's no obligation or mandatory rule to say every case has to go through the 10 steps. Clarify documentation if needed, facilitate the document exchange, and an investigator. I always pause here. An investigator is not necessary in every single case. 1, they are expensive. 2, they're time consuming. 3, what do they create? A report. They're going to interview Grant, they're going to interview Mike, they're going to interview Jill, they're going to interview me, and they're going to say, this is what they all said, and I think it's a code of conduct violation. It's a piece of evidence. Yes, there are times to have an investigation. Most of the time there are not. Established fair timelines. Try and keep things moving. Hey, Grant, I'm the case manager. Mike's filing a complaint against you. I would like to have your written response in 14 days. Well, Steve, I'm off to Florida for 3 months, and then I'm going to China for 2 weeks. Could I have an extra week? Yeah, of course you can. But you can't have 3 months. You can have an extra week. So be reasonable. Establish the timelines, determine the appropriate process, and then, of course, share the decision. You want to be proactive, too, on the distribution of the decision. Is it public? Is it confidential? And the majority of sports today, particularly in the newspaper articles, are being slammed for not sharing the outcome of disciplinary processes. So a lot of times when we write discipline policies, it says the decision will be public unless the panel decides otherwise. That gives it, rather than the other way around. And there will be situations where it's not appropriate that a decision be published, or it involves minors, things like that. So when you become aware of a dispute, take it seriously, be proactive, talk to people. Again, quick story, years ago, hi, Steve, we got a complaint. Yeah, can you case manage it? Yes. How long have you had it? 9 months. Oh my, what have you been doing for 9 months? Well, we kind of forgot about it and got lost in the shuffle. Okay, give me the names of the parties. They do. I call them. Hi, Grant. My name's Steve. I'm the case manager. I will be responsible for the facilitating your complaint. What's the remedy you're looking for? I just want an apology. What? What? That's all you want? Yes. All I want is an apology. Hi, Mike. My name's Steve. I'm the case manager. There's a complaint filed against you. The complainant is looking for an apology. If you don't want to give an apology, we'll have a hearing in 2 weeks. Who do I make it out to? When I listen to the parties and I engage with the parties and I deal with things in a timely manner, usually you hope reasonableness will prevail. So taking quick action is really important. When you're the case manager, the facilitator of the process, you're neutral. You don't have an opinion. A lot of times when we talk about complaints, we have the case manager to do the administration and then the discipline panel who decides guilty or not guilty. So try not to convolute those roles into the same person. Be confidential, be discreet, define the focus, the complaint, be forthright and transparent. Grant, I appreciate you're going on vacation, but this is a serious matter. I will give you an extra week to file a defense, and the hearing will be on November 2nd. So I really suggest you be there. Now be fair, but be forthright. And be bold. A lot of times lawyers get involved and they will try to push you around on administrative issues and they're going to take it to court. They don't. It's too expensive. It's very rare that it happens. So be bold, but be fair in the way in which you manage a complaint. So I'm going to stop there on maybe we do another session on employment. I'm going to post, hold on, I'm going to post my, bear with me. I'm going to post my contact info. Is it okay? There we go. So obviously you can tell when we talk about sport law, there are a lot of things that we can talk about. When I started practicing sport law in 2003, I really didn't believe there was a full-time job here. I was like, oh, it'll be something I can do part-time, something I can do to help and give back to sport, which was always great for me, as Jill alluded to, as an athlete and a coach, and now for my kids. But I was wrong, and it's a very difficult place to play these days. Understanding that it becomes more onerous and more legal and more responsible daily. So again, very happy to stay on right now and answer questions. If people aren't comfortable, there's my email address. Feel free to please send Mike or I an email. We're happy to respond, set up a call to help you out. So thanks, Jill, and I'll let you play Oprah.
Well, I mean, thanks, Steve. Every time you do that, I learn something new. And we will definitely, I want to say that I keyed in on making sure that the abuse policy that we had shared with all of our clubs is the same as Pickleball Canada. So we will do that as a priority. I also just wanted to mention that we are working on a repository of resources for our clubs, such as policy templates, all of that kind of stuff. Some have been released already and that are posted. We will continue to work on that for you guys and we'll try to prioritize as much as we can. But again, like I think it's more than fair to say Pickleball Alberta exists to benefit you as clubs. So please, if there are questions along the way, we're here to help. And obviously, we know great people like Steve that are in our service as well. So hopefully, you guys felt engaged. Grant, you came off mute. Go ahead.
Yeah. So the more I learn, the more I know I don't know. So I guess my biggest question is, okay, so we're heading, next next May we'll be starting again, and I know of all these things that we probably don't have in place, or I'm going to be looking into it anyway. So I guess how does a person run the club with maybe having a bunch of these things that aren't in place?
That's a great question. So what I think we'll
Yeah.
do, or I'll propose, to our board is that we will prioritize making sure, because I know a lot of our clubs are new, just due to the state of pickleball in general. And so we can set our sights on developing some easy tools for our clubs, like a checklist. Like, these are the things that we recommend you do before you open your doors when the season is here. Also, Grant, we are planning a whole weekend of seminars and workshops like this. I think it'll be in Red Deer in the spring. I'm not sure if we have dates yet. Della can chime in if we do. But I mean, also attend that, because the learning that happens over the course of that weekend is pretty tremendous. Watch your email for all of the stuff coming out from us as well. Of course, we can always put the information out there, but understanding how important this stuff is, like, we don't mean to scare the crap out of you, but we kind of do, right? Because we want to protect you guys and our pickleball players. So it is super important that we work together. And if we could lean on you guys to spread the word, right? Like, hopefully next time we get some more people on these webinars and lots of people watch the recording, but please help us on that front as well.
Yeah, the only thing I'll mention is I saw it in the email, but tonight was the first. I didn't know ahead of, so I'm guessing some people probably
Yeah.
got caught by
Yeah, there
that.
was a
So
miscommunication on our part for sure.
okay,
So we'll
yeah,
get that out way sooner in the future. So
yeah. So yeah, that's good. Yeah, because like I say, I appreciate the information I'm getting. Yeah, makes me realize there's a whole lot more stuff that I don't know. So anyway.
Grant, I appreciate you saying that, and it's very helpful. One, Jill works in the system, so she's very knowledgeable. You need help, we're here. We're not recreating the wheel on a lot of the things that you would require. Feel free to reach out. And again, pick stuff off. So, I'm going to pretend you're a new club. Okay, I'm a new club. What's the first things I need to do? Well, my registration form, my waiver. Okay, I'm going to work on that, get that done. Now I want to make sure I have my foundational policies in place. What are those? Can I borrow them from Pickleball Canada? Can I borrow them from Pickleball Alberta? And you just keep moving forward. So please don't look at this as saying, oh my God, I'm not incorporated. I don't have registration forms. I don't have waivers. I don't have a complaint management policy. Like, just pick a couple and you'll keep moving forward. And please don't go try and recreate the wheel. It exists. Okay. Hi, Jill. Hi, Adela. I need a code of conduct. Can you point me in the right direction? They'll do it or I'll do it. We'll figure it out. Okay. Yeah.
agreed. Anything else from anybody on the call? Okay, well, with that then, we actually ended like bang on time for the record here,
Yeah.
guys. 8:15 here, and thanks for staying up a little bit late with us, Steve. He's out
Yeah, no
east, so a
problem.
couple hours later. We'll circle back to you, I'm sure, in the future and lean on you guys again. But thank you so much for your time, and thanks everybody on the call. Best of luck, and how to reach us with any follow-up.
Yeah, thank you very much.
Awesome. Yeah,
Thanks,
and you bet.
everybody. Have a
Take
good
care,
night.
guys.
Bye-bye.